Good evening, ladies and gentlemen. Welcome to our second event of our inaugural season of the Law and Tech Talks. We had the first event in November, and this is our second event. Today, we will talk about the trends and challenges of harmonization of data protection standards. We have a very well-composed panel. Dr. José Lupi, on my right, here with us, is a lawyer and managing partner at Lupi and Associates here in Macau. We also have online Mr. Igor Gonçalves, who is also a lawyer and a partner at APSV Advogados in Brazil. And our own head of Department of Law and Public Policy at the Faculty of Business and Law in USJ, Associate Professor Ansuman Duti Diakite. Join me in welcoming our esteemed guests here with a round of applause. And myself, I am Ângelo Patricio Rafael, an assistant professor at the Faculty of Business and Law of the University of St. Joseph. In 30 seconds, I will ask my guests to introduce themselves, talk a bit more about themselves, what they do, it's also regarding this area. But I would like to thank the audience for taking the time to come here, and also those that are attending online. Thank you very much for coming. So now I will ask our speakers. I'll start maybe with José first. You can talk a bit about what you do and your practice, etc. Right? And then I will ask the other speakers as well to introduce themselves.
Thank you so much, Dr. Professor Ângelo Rafael. Thank you so much also to the Foundation Rui Cunha for the opportunity to be here, and to Professor Diakite for being here, and for our colleague Igor in Brazil. My name is José Lupi. I'm a Macau lawyer, also qualified in Portugal and Brazil. I've been in China since 2009, having spent 8 years in Beijing working with a large international firm called King & Wood Mallesons. My practice mostly focused on energy resources while I was in Beijing, but in Macau, because of the size of the jurisdiction, we do a bit of every practice. And obviously, with a very focused on data protection and data privacy, given the customers from mainland China, Hong Kong, and Macau. So I also have a PhD from the China University of Political Science and Law and International Law, and a Master in International Business from the Chongqing University. So to all the ones doing the MBA program here, Jayo, and thank you very much for taking the time to come at 6:30 in the middle of a week of work and studies. Thank you.
Thank you. I will greet our speaker that is online. Igor, can you introduce yourself?
Yes, sure. Well, first, thank you very much for the invitation and the opportunity to be here today as someone who strongly believes in the power of international cooperation. I see events like this as a great opportunity to foster connection, to build a stronger bonds between our countries and our entities as well. So my name is Igor Maia Gonçalves. I'm a Brazilian lawyer specialized in foreign direct investments, especially in infrastructure and the energy sectors. Over the last 15 years, I've worked on business and transaction involving more than 30 countries. I'm a partner in a Brazilian corporate law firm, which is APSV, where I lead the international practice. And I also serve currently as the president of the Chamber of Foreign Investments and International Trade within our States Development Agency government here in Ceará. I'm also the representative of the Brazil-Canada Chamber of Commerce here in my state as well. And I'm also a professor here in few universities. And this is another reason why I'm so happy to be here in an academic environment as well, because I truly believe that this alignment between the market and the academia are essential. So thank you very much.
Thank you very much. Professor Diakite?
Thank you very much. You can understand how challenging it is to be between lawyers. Even though I'm not a lawyer, but I'm a lawyer by training. I have a bachelor degree in law, international business law, master degree in international investment law. I did my PhD on China-Africa relations, which is more international relations. And recently I've been focused on doing research on law and technology. And this has been my new area after my PhD, of course. Recently I was lucky and to get funding from Macau Foundation to conduct a research on cross-border data transfer between China and Portuguese-speaking country, which was successfully completed in June last year. And since then, I am more and more interested in divulgating the outcome of the research that I did last year. And in terms of years in Macau, sometimes I feel shy to say how many years I've been in Macau, because I'm almost by next year I will be 20 years in Macau, not same as Jose. But yes, I'm happy to be here, and again, thanks to our partner for giving us the opportunity again to discuss this topic in the second round of our Law and Tech Talk. Over to you.
Thank you very much. Well, let's start. We are going to talk about harmonization of data protection standards. But often, and this was the first question that came to my mind, is why do we need to harmonize? But maybe will be interesting also for the non-lawyers that are here. What do we mean by harmonization? Right? We can begin by that. And I will ask Jose to start, and then we can hear a bit from Igor that is online.
Okay, why do we need to harmonize? I would say, especially given such a variety, such a diverse audience, I would say two key reasons. One was cost. Because when we're talking about harmonizing, we're talking, or at least from my perspective, there's a tendency to be talking more about the companies that have the data. So cost in terms of transferring them across multiple jurisdictions, if we're talking about multinational companies, which in the case of Macau and the Greater Bay Area and Hong Kong, we most likely would, especially because for the purpose of cross-border data transfers, GBA, Macau and Hong Kong would count as cross-border transfers. And the second one is innovation. So, to innovate and for you to create and for you to build businesses and operations, you need data and information, you need know-how. And so it is key for this data transfers to happen. They need to be protected. If you don't have harmonization, you have significant costs, which if you're just talking about GBA, Hong Kong, in Macau can be 3 times what it could be if they were harmonized. If you're talking about an operation truly international involving other countries and other jurisdictions, then that cost grows proportionally. So I would say, from my perspective, and we have been advising clients very recently on exactly that topic, how do you minimize costs, including with lawyers? So, yes.
Yes, and in talking about costs, and now I will go to Igor. And in talking about costs, besides lawyers, of course, what other types of costs can we think about when we have a situation of non-harmonized laws and regulations in different countries and jurisdictions and regions?
Well, I would put it in a more conceptual aspect. I think that this is connected to a broader aspect of internationalization. Not only, of course, we are talking here about the data protection, but I would bring it to a more global aspect and concept. I mean, the success of your interaction with the world, it's not just about your openness to it, but it's mainly actually about so just to your readiness to giving your partners the confidence that they will find the same protections and safeguards they rely on at home. So this approach ultimately makes markets more competitive in a level of playing field. And putting it in a perspective also about data protection, ensuring that everyone is playing by a common or similar set of rules makes the global business environment more predictable, trustworthy, and when countries adopt aligned rules, they create a familiar environment for, I'll put here in the perspective of foreign investors. Okay, so it reduces legal uncertainty and smoothing also these cross-border transactions.
Thank you very much. I don't know if
Yes, first, you asked the question about what is the concept of first harmonizations and why. And before talking about the cause, I think it's important, as I promised my colleagues, that I'm going to make sure students got the key concept I'm going to talk. First, why we have harmonization. The harmonization means there is a reason behind it, because each country has their own law on data protections, right? Each country sets rules about conditions for transferring data from one point to another point. And with this variety of rules and regulations, what happened is that, as Jose mentioned, it creates a cost. It creates a cost. Some of you probably working or running business. When you need to take a data from one to another country and you have to face restriction, or you have to face some what we usually call requirement to keep the data in the country where you are getting the data, this affects your ability to operate from international perspective. If you are involved in a supply chain management, or you are a communication company where data is essential for your operations, it's going to be a problem. So that's what gives the reason for, that's what justify, let's say, the reason to harmonize the laws regarding data protection. When you say data protection, not only substantive rules, but also we are talking about data moving from one point to another point. How can we make sure that countries have a similar requirement, not putting any burden or cost on the business, precisely small and medium enterprises that are involved in international business? That's the first thing. The second thing, talking about the cost, I will not repeat more, but Jose mentioned something about the cost. The cost is what? So if you need, for example, as a company, to move from China, your operation from China, to go to, let's say, Belgium, where in Belgium you are not allowed to export the data, for example, or China is not allowed to export the data. So you are required to set up a mechanism in Belgium to guarantee the data protection. So basically it increases your cost, operation cost, by the fact that you need to find a mechanism for compliance, paying for lawyers, and several reasons that might push your cost to increase, and which make the business less competitive, right? So I'm not from the business field, but I know you are from there, you study business, you understand what raised the cost of business. So third reason I'm going to mention, there is no business that like legal uncertainty. What does it mean? It means that when you understand that you are not secure about the law of a country where you are going to invest, you are going to transfer your data, you don't want to go, because first you have some requirement. For example, European companies, for example, that are under the GDPR, they are under strict requirement to make sure that some principles are respected before transferring data in a third country. So those are requirements. And definitely it refrains company from exporting, from going beyond their border, right? If I may just add those few things, I know I went more than what you asked me. There's just a few comments I wanted to add.
That's very, very good indeed. When we talk about harmonization, we are assuming that something is different or something is not harmonized, right? But if we talk about data protection laws, for one that may want to simply read different laws, may probably find things in common, right? So it doesn't mean that everything is different from the start in data protection laws. There are probably principles, there are standards that we can find in virtually all laws. And maybe I can start with you.
Yes. If we take a look, you rightly mentioned that most data protection laws have similar principles or similar set of rights for data subject. First, but before explaining more those similarity, I want you to understand that first, what's the approach for data protection law? Data protection law approach is first, there's a two type of interests that are there. One interest is to guarantee the business, right? Because if you refrain from data transfer or using processing data, business need data, right? So first constraint is the second constraint is the right of the person that data has been collected and been used. What the right of that person? Is that person has a right to say no to the use of his data? Can that person say, don't use my data again, give me back my data, erase my data from your website? So that is the strike balance that data protection law put in place, right? On one hand is guaranteeing the benefit of the private company, but also the securing the right of the data subject. So this brings me to two things that are very common in many data protection regulation, be it domestic level, meaning that country level, or regional levels, or even at international levels. You have very common principles that are there. I don't have all in mind, but I can give you some of the principles that are common to all. For example, is the principle of lawfulness, fairness, and transparency in data collection. So what does it mean concretely? So if you want to collect my data, you have to collect it lawfully, meaning it has to have a legal basis for collecting my data. What are the usually most of the data protection law sets as a requirement is the consent of the data subject. If you want to collect my data, I need to guarantee that, yes, I agree you to collect my data, right? So that's one reason. Or second reason, it can be because of there is existence of contract, right? Sometime for contractor relation, HR needs some one HR company HR in Macau and one in Hong Kong need to transmit those information between HR. This is another reason can justify the transfer. So you have also the data minimization principle, which is also consecrated in many data protection law. It means you collect the number of data, right, that is required, right? Collect what you need, right? And you need to collect for a purpose, legitimate purpose. And the data you collect has to be accurate. So meaning that you cannot take my data and then maybe my birthday is wrong. It's not you're breaking my data right as a data subject. Because simply the law requires you, when you are putting my data, you need to accurately put my data with no mistakes. And also, beside that one, there is also what is common to many data protection law is the principle of accountability, which is a very interesting principle. Why? Because sometimes those who are using or processing data are private companies, right? It could also be public institutions. That's what we usually call data controller and data processor. Those who have the data and then those who are processing data under the instruction of data controller. So usually there is that principle of accountability. It requires those who are controlling data to take all the necessary measures to make sure that the data that are collected through them are used and follow all the principles that are common to all data protection law, be it domestic, international. You have a small variation of the terminology of some, but mainly they all say the same thing. Just the last point I want to mention that are also you can find in many international laws, international norms on data protection, regional norms, or at country level, even at guideline or soft law level. those are the rights that are given or granted to data subject. What we mean by data subject is the person that data has been collected. So legally we call him data subject, right? So that person is being granted several rights: the right of access to his data, the right to ask for deleting his data, erasure of his data, a right to ask to send him his data that is in the more readable conditions, and so on and so forth. So those are a few of the rights that are common or we can find in many legal instruments related to data protections. But because we are talking about harmonization, so this is the starting point for the time being in the current regime on data protection. We see a kind of alignment in many legal instruments at all levels on principles, but also on the rights that are granted to the data subject.
Thank you. We talk about harmonization, and now we know that we have common principles that can be found across virtually all jurisdictions, but we also have an aspect of how these common principles are implemented into practice. We will come back to that point later, but for now I would like to come to José and Igor, related to harmonization itself, the process of harmonization. Based on your experience and based on what you have been observing, how does this process of harmonizing data protection laws and regulation, how does this process normally take place?
You want me to go first?
Yes.
So thank you, Professor. And picking up on what Professor Diakité mentioned of the common principles. So, and correct me if I'm wrong, I understand these will mostly be derived by OECD privacy principles, right? So this creates a common language across virtually every data protection laws. There are estimates that you have around 140 worldwide. Even when you look at the China data protection law, which is obviously more security focused, they also incorporate this language for harmonization purposes. Now, obviously, one thing is the harmonization, then is the implementation of this harmonization. So when you look in the context of the Greater Bay Area, you do have these standard contracts that were launched in 2024 GBA Macau and 2023, I believe, if I'm not mistaken, to Hong Kong, that standardize contractual clauses for these cross-border transfers. So I would say if you pick on the Greater Bay Area experience versus, I would say, the European experience, the European will take a top-down approach, more on European directives, implementation at the local regulations, whereas the GBA will be more of a bottom-up approach, more practical, right? So you have the two countries, one system, which one country, two systems, which in reality is one country, three systems, and you start with the standard clauses and you look at the practical issues, including implementation, because sometimes the law can say the same, the concepts can be the same, but the authorities might apply them differently, and you build from there up. So it's an interesting duality of approaches, which, if I'm allowed to take an opinion, I think, especially for the region where we are, the bottom-up makes more sense because it's more practical and addresses the commercial problems that both the objects of the data, so the personal data providers and the companies managing them face.
And you mentioned this bottom-up approach. Just to clarify, is this related to the idea of this standard,
yes,
this model contract?
Yes.
And how does this work?
So basically, when you look in picking up again on what Professor Diakité mentioned on the harmonizing principles, when you look, for instance, at a retailer who if has operations in Macau, likely will have operations in China, right? We're talking about one of the largest consumption markets in the world. And most likely, if you think from a business strategy perspective, also Hong Kong makes sense. So, and you're analyzing client patterns, for instance, buying patterns, when you're looking at your employee data, because from operational perspective, maybe it makes more sense to manage it from Hong Kong, from mainland China, or from Macau, wherever the case that might be. you need to transfer them. And as Professor Diakite rightfully mentioned, in all the main principles, the lawfulness and the necessity, this necessity many times is proven by contracts. Now, the authorities might not require it. For instance, in Macau, I understand they didn't, at least up until recently, but this serves as further evidence of why the business needs this, and especially in a world more interconnected and with technology and artificial intelligence and with the algorithms measuring the patterns. This is all information that is absolutely critical for the businesses. So the standard contract facilitates that, and in the case of the GBA, and it's only for the GBA. So if you're managing HR, for instance, from Beijing or from Shanghai, you need to have different considerations, and it's also GBA Macau and GBA Hong Kong. So separately, you cannot. Well, you can package in one, but there's a set of complexities that arrive from there. I would say that's the way to go about it.
Thank you. Igor, now going to you, can you share your experience in Brazil or in South America? How is this process of harmonization? How does this process take place? And what's your experience on that side of the world?
Well, perfect. I believe that this moment right now is a clear evidence of this practical harmonization, because it's really interesting to see how we are here now discussing over the same core principles also in the different sides of the world. The Brazilian data protection, all the framework is strongly inspired in GDPR. So I believe this is the first inspiration for the legislation worldwide. And in terms of our journey through this subject, I would start framing the entire approach, mentioning that this movement here, it began by recognizing personal data as a fundamental constitutional right. This was a very symbolic and transformative step for us, because we put the data protection into the core of our constitution. So we elevated it to the level of a basic human right. And this shifts actually and change the perspective on how we view and how we enforce through the infralegal legislation and framework this right, giving it a strong foundation and underscoring the sensitivity and also the importance of protecting personal data. So starting from that, it was structured all the framework and the Brazilian model for it, starting also in the next step by the creation of Data Protection Authority, which is a federal body responsible both for creating the rules and also overseeing the compliance with our legislation. In terms of empirical or practical application here, I would mention this as one topic that is stand out.
Thank you very much. Well, I know that you worked on this project that you mentioned in the beginning, Portuguese-speaking countries. So I imagine you might have gotten some experience on Portuguese-speaking countries, the majority of which African countries. Could you share some insights on your research, or your experience regarding this process of harmonization of data protection in, for example, in the African context?
Okay. Although my research was not fully on harmonizations, it was to look into what exists as a norm to facilitate cross-border data transfer. But of course, there is some dimension of harmonizations, even though it's not the goal, but in the end, I will have to propose some harmonization because there are some discrepancies between legislations, and not only discrepancy, because some Portuguese-speaking countries in Africa do not, even not in Africa, also in Asia, do not have per se data protection law yet, right? And Mozambique is one of them. I don't know up to now if they have already the new law, because the data protection was scattered in different legislations, like e-commerce law, law on telecommunications. So those different sectoral laws was dealing with that. So the most advanced in the Portuguese-speaking country, of course, beside Africa, of course, is Portugal and Brazil. And as Igor mentioned, Brazil, the law on data protections, it's fully mirror to the GDPR, right? In terms of requirements, of course, there are some slight differences, right? In terms of compliance mechanism, but also sanctions or fine is completely, there might be some differences there. But in the Portuguese-speaking countries, what I come to know is that, of course, most of those who have at least data protection law are mainly aligned with the Portugal data protection law, which is also because before the GDPR, you have the directive, right? The directive in 1985 that was guiding data protection in Europe before the GDPR, which the GDPR after when come back and then took some of the things of the directive and also make those norms become more enforceable and bindings, right? So most of the Portuguese-speaking country data protection law I took a look into mainly have similar provisions on like the one at GDPR. Just give you an example, which is mainly discussed in the context of EU GDPR, is the principle of adequacy, right? When that require that company in Europe can only transfer data in the third-party countries that have similar or adequate data protection law, right? So the same thing, you can find it in Cape Verde data protection law, right? And beside that, we have others that don't have data protection law, but they are part of regional integrations, right? For example, even though Mozambique don't have data protection law, or Guinea-Bissau, for example, doesn't have a data protection law per se, but they are part of the regional agreements, regional instrument, for example, ECOWAS instrument of data protection. Guinea-Bissau is part of that. Also, the continental project, the Malabo Conventions on data, cybersecurity and data protection at continental level, they have signed those treaties. But as a treaties, it requires just country to take law at local level to protect data, right? So those are some of the effort already in terms of harmonizations and bringing together countries' laws on data protections.
And this I put to all speakers. Is harmonization normally, we were so far talking mainly about laws, they talked about the model contracts, but I would like to understand what are the different strategies, laws in the positive laws in this case, the only way or the most important way or the most prevalent way of harmonizing data protection standards, or based on experience, there are other approaches, there are other ways that either the corporate world or governments adopt to try to align these data protection standards. Maybe we can hear from Igor first.
Sure. Well, you mentioned the adequacy from the perspective of European authorities. So we had this recent publication of the draft decision recognizing Brazil as an adequate country for data protection purpose. So Brazil is on this track to be officially acknowledged as meeting European standards, which is a major recognition for us. And of course, we can treat this in terms of practical negotiation between the parts, because when we have a legislation that also rules international transfer, it eventually goes beyond its own jurisdiction. So in countries like Brazil, that the foreign direct investment is very strategic, it affects our business. It has affected actually even before we have our own legislation here, because we have this chain effect. As the European companies to operate in Brazil, they had to assure the safeguards of all the data that was being using here. We have all this contract engineering and negotiable engineering and structuring that allow them to operate in other countries. So this is a practical implication that I could mention that goes beyond just the local jurisdiction, but also creates this mandatory effect regarding the market. The market rules just as the legislation, I would say.
Thank you.
Yeah, well, picking up on what Igor said, I absolutely agree. So legislation is absolutely necessary. You know, it's the way to make sure there is harmonization and to make sure there is due process, etc. I do think the China approach, the bottom up that we mentioned a while ago from the one country, two systems, is also critical with you know, with standard contracts. I believe, Igor, correct me if I'm wrong, but I believe Brazil will also have standard contractual clauses, if I'm not mistaken. So I think this is a very practical way. So if you put yourself in the perspective of businesses, even if the law or governments or politics do not put in place ways and systems to harmonize data transfers, the businesses will, because even if cost is not a consideration, it is always a consideration, even in terms of work spent and to navigate. You know, if you're talking about 140 different data privacy laws, they will find systems. So the market rules, absolutely, and I think it needs to be a combined approach because again, laws are made by legislators, whereas businesses are the ones on the ground seeing, you know, the development, especially nowadays with artificial intelligence, the technology advances, the speed that data flows. You know, I do think that the standard contracts and standard contractual clauses are critical.
I agree with my two other panelists. Okay, standard contract clause are one of the ways to do that. What we mean by standard contractual clause, so those are contracts with a standard clause, basically. It's a standard clause setting the rights, the obligations of both parties, the person controlling data and the person processing the data. So if I collect your data, I have your data as a part of my database. I'm a data controller. If I need to give to Angelo to process it, Angelo is a data processor acting under my instruction to process those data, to tell him what to do. Usually we see most that one in e-commerce business, right? So, but just for clarification of the concept, standard closed contracts are important at as he say, at the bottom level. Bottom level meaning because there's different way to harmonize. You can start from the bottom, you can start from the top. So at bottom levels, it's more like a companies signing contract to make sure that they can guarantee protection of data. And even if you look at, I'm sure from Brazil data protection law and European Union protection law, one of the exceptions to guarantee the adequacy principle is the existence of standard clause contract. If the standard clause contract exists, it will be a justification for allowing the countries to allow the company to transfer the data to a third countries, and with the data processor that is fully accountable under the standard clause. But also, your question is that what are other mechanisms, right? So, of course, I agree with my panel members. Legislation is a tool, but legislation is also a problem sometimes. It's a tool, but it's also a problem. Precisely when we talk about harmonization at international level, right? So, we see many times countries breaking international law. I don't want to mention names, but if you're watching TV, you know. So law, it's not a tool that usually, at the moment, that's something that's convincing as a tool really to make sure that things can be enforced. So, but that's what you usually call hard law, right? Those laws that are must be implemented. Usually, there are several of it, right? So let's just mention, for example, the European Council Convention 108, which is about automatic processing of data. This is a binding international treaties, right? I mean that countries that are part of it must implement the obligations that are imposed on them by those treaties. Okay, but again, it still requires most of the time countries to take extra measure to implement those norms. On the side of the hard law, you have what you call soft law. The soft law are those guideline, because mainly in international relations, the forcing does not help to solve problems. Sometimes is having the soft law, we call soft law, is a law that is soft, where everybody feel like I don't feel obliged, but because it's nice, then I'm going to implement it. So there's no obligation, but because it's nice, because everybody is doing it, people start following those guidelines. So you have several guidelines. Jose mentioned at the beginning the OECD data privacy guideline. This is already was one of the first norms in 1980s that sets principles related to data protection, right? So it was already a beginning of thinking of harmonizations, because you have already those norms telling countries that, okay, this is the solution you have, we're providing you, you can use this solution to address the data protection issue. And also to avoid having a contradictory norms between different states, because if you all adopt this norm, you may have the same content of the law, and it's easy to transfer data from one to another, right? So that's more at international level. But also at regional level, there have been some effort there as well, right? So regionally instruments, like for example, European Union, GDPR, it's one of the typical example of harmonization of data protection rule within the 27 countries in Europe, right? So it means simply that if you are taking data from France to Germany, you're not subject to the adequacy principle, because all are considered to be implementing the same norm, because the GDPR, it's a regulation that is implemented directly, no need any transposition in the domestic legal system. So it's applied immediately. So all countries that are part of the European Union are bound by those principles. So this is one of the approach at regional level for facilitating this data harmonization of data rule. But also, one last thing to not take more time, you have also new mechanisms that are also integrated in many data protection law to facilitate this harmonization at the bottom level, because what I was thinking is more top level, international norms, regional norm. Beside the standard contract clause, we have, for example, what you call the binding rules, a corporate binding rule. The corporate binding rules is what? Is the company itself decide to integrate, for example, usually those big company with the big operation that are group, like a group of company, multinational corporation that are group, right, that are different subsidiary in different countries. So they will adopt what you call binding corporate rules that serve as a guarantee for cross data transfer between the group and the subsidiary, for example. This has also served as a basis for facilitating harmonizations of standards in terms of data protection and cross-border data transfer as well.
Thank you. Just one question. Since you spent a lot of time in China and you studied also in China and you practice in Macau, but you also have some background about Europe. And of course, the question is not only restricted to you, but I would like to hear from you first. We talked a lot about GDPR, and we repeat a lot. GDPR probably today is the most influential piece of legislation out there. But are there other models in the world? For example, how about China? Like, what's approach that? I think you mentioned a little bit in the beginning China's approach to data protection in general. Is it more aligned with the European Union approach, or what's China's approach in this case?
So I would say the GDPR is very unique, and I think as all the panel members mentioned, it takes a bit of a leading role globally that is mimicked by several countries, including Brazil. But China's approach, I think, is very interesting. It's more complex, but very interesting. So you have the data privacy law, you have the data security law, and you have the cybersecurity law. So one is focused on the issues within the privacy, the personal information law is based on the issues it's the one that regulates the issues we've been discussing. Then you have data safety, which comes about on how do you manage the data that you collect. And then the cybersecurity, what is the infrastructure? So obviously, I would say Chinese data privacy laws, in my opinion, and this might be controversial, but I think that's what you're asking me to do. I would say, to an extent, is more, I would say, more practical and more advanced than the GDPR. Because when we look at the GDPR, Europe is not exactly known as a beacon of innovation nowadays, despite all the geopolitical tensions. In fact, there are arguments to the contrary. So when you go look, for instance, at the fines imposed by the European Union, you need to forgive me if the numbers are not completely accurate, but I came up with numbers of, 2.3 billion a year in fines. So in the news, if you accompany the news, is full of issues as well. So the China data privacy laws are more focused, and I did mention this, in security, which is normal and is legitimate in its national interests. But I do think it works quite well. But I don't want to risk delving too much into technical issues, because I'm obviously not a PRC qualified lawyer, and I just have a close viewer position, but not that close.
Thank you. And going a bit to Brazil, I know that it was mentioned already several times that it's heavily inspired by the GDPR. I don't know if you have other experiences on more regional level. What are other countries in the region doing? Are they following also the European Union approach? Do you know anything, for example, about the United States? Normally, I tend to see that the United States has some influence sometimes in Brazilian legislation, but apparently not in this case. Does U.S. approach have any influence, for example, in other regional jurisdictions there in the American continent?
Well, yes. I would say that United States has a broad influence in several terms and aspects, not only jurisdiction, but also in market, considering their strength in power and influence over the world. But specifically regarding the data protection aspects and legislation, GDPR and Europe are by far our main influence here. However, the Brazilian legislation was tailored to make feasible the discussion and interaction with the whole world. So we do have a dedicated regulation specifically for international data transfers. We also have this review or this establishment in the legislation for a delinquency list, which is still in work. But right now we have from the national authorities some other tools, as Professor Diquier and Jose also mention it, like the mandatory contractual clause that can be used in the exact specific terms, and it also might be, if necessary, for any reason, even for the negotiation or to be aligned with other jurisdiction legislation, it can be adjusted as long as you submit it first to the national authority so they can check if these other terms and conditions are also aligned with the Brazilian legislation. So despite this influence, it's not so restrictive from the point of view of global interactions.
Yes. Well, we talked, I think, a lot about the process of harmonization and the different approaches that we have. But what's the situation, right? There have been several efforts. There are different guidelines. There are different approaches, model contracts, etc. What do you feel is the current situation? Are there any? Do we still face a lot of disparities, a lot of lack of harmony, or we are more or less in a situation of convergence, let's say, of the desired state? Or what are the main areas on which we need to do more work? Well, we can start with maybe Isaiah, if you want.
Well, I would say yes, absolutely. Harmonization is the way. It's where the convergence is where we're walking towards. I would say it's also a necessity, mostly because law follows the market, in this case the businesses, and the businesses want to harmonize to navigate simpler. So I think harmonization is definitely the way forward. And then the main challenge is it's then application and implementation of these laws, right? So we can have the same concepts, we can interpret it, but then how they're interpreted and how they're applied, and what are the priorities of each country. So we touched a bit just earlier on the whole GDPR, PIPL situation, and where do I see more practical and not more practical. But in the end of the day, data is a commodity from a business perspective in today's world. Countries have their own national interests, and so the concept of the adequacy is also, in my view, and now speaking a bit more out of the legal terms, is what is adequate to which party. So I would say application of the laws and implementations is the key issue. Also, again, going back a bit to the beginning of what I mentioned, the challenges, because it's related to costs. So I will not dig into it now, but if we look at the amount of fines, and not only compliance costs, but the amount of fines on very significant companies and operations that have been going for data breaches are very significant. So yes, I would say implementation and application.
Well, main challenges that we face now to have the desired state of harmonization if we don't have it.
I think I agree. First, one thing I want to say, harmonization is a journey, is not a destination in this case, because several process has been implemented. I agree, implementation is the issue, but also there are some realities, national realities, policy options that make it a little bit difficult. I explain why. First, beside the fact that I'm the one that mentions the convergence in terms of principles and rights that are granted, but data protections are not only based on that the two elements. The approach, how country sees data protection might be different, right? So the way Europe GDPR is designed and the overarching goal of the GDPR might not be the same as China overarching goal in terms of data protections. It's not the same as United States. You mentioned United States. Each of these reflect a model that are unique and reflect their national interests, right? It could be political or economic interests. For example, I read an article on what's the difference between China models in the United States and European. So China data protection model is mainly national security focus. Europeans is more focused on individual rights, because in the context of Europe, it's considered a fundamental right. I think the same as Brazil, right? And in the context of United States, it's completely different. It's more focused on the private entity or private company right or focus, right? So having this mindset or model, you see, it's very difficult to design a rules that will satisfy the interests of all. That's one reason. Second reason, Jose mentioned the geopolitical aspect of data protection cannot be overlooked. You know, each country, just China and United States, are a typical example of that, right? United States recently in 2024 take a executive order by refraining any data transfer from United States to countries that are considered to be country of concern, in which China is a part of those, right? So how would you think of harmonizing or having a global norm or global standards where you have this kind of geopolitical fights within the countries that are aimed to come up with something? But that is one thing. But we cannot also talk about data protection without considering the developing countries. Developing countries has their own reality in terms of data protection, because they are part of the global community, right? So then they have their own say. But two issues we find in developing countries. First, it's those who have a law right now, they are more implementing what we call data localizations requirements, meaning that they require data to stay within the country. And the reason for that is economic reason, because they want company to build data center within those countries and be able to process data there. So that's the economic reason. Right, that other country may not have. And if you talk about data localization, you mean you are refraining company from transferring the data from A to B. I mean, they can use data, but they use data in the country where data is generated. So this is one of the issues, and many countries also have this requirement, right? And the last things that also for me, it's a problem that my dear friend Grasa mentioned last time when she was here. It's the cultural elements in data protection. Not every culture see data privacy has requirements, right? So if you are in a collectivist cultures or you're individualist cultures, they don't see the same, right? So this is all these elements have to be taken into considerations. But should we be skeptical or pessimistic about data harmonization? No, of course, there is still work that has been done at international level. I mentioned some of the soft law, soft norm that has been put that sets some standards already. And we've seen that, I think my two panelists members mentioned how, and using your terms, how country mimic European GDPR standards. It's not only Brazil, but also many countries in Africa are also following the GDPR standards, right? And most importantly, there is also the fact that the GDPR require the adequacy decisions. Many countries are trying to get the adequacy decision. Brazil just got one now, meaning that they need to be considered to be adequate country that has the same standard as the European Union. By doing so, we are making an alignment, right? There's an alignment with the European standard through the adequacy decision, right? So those are the things that I think are for the timing, beside the fact that there are some challenges, but there are some progress. If we nurture those progress, we can not in the next 5 years, next 10 years, but in the long run, we may reach a lot of convergence between data protection norms.
Well, that's very interesting. You touched a point about data localization,
Yeah.
and this goes in line, it's in the same context of conversation when we talk about the GDPR's adequacy principle. This reflects a bit, let's say, different levels of the requirement that is needed. Some more closed systems, some will allow this transfer of data within certain conditions. I don't know if, José, you want to talk a bit about this, explaining like these differences. Some countries totally they will have very strict data localization requirements. Other jurisdictions, such as the European Union, will adopt this adequacy principle. Maybe we can talk a bit more about that, just to see the different realities.
Right. Well, without digging too much in the technical part and the decisions behind it, going a bit more again to the geopolitical side of it, I think the countries adopting strong localization requirements, if I'm a politician and if I'm running, even if it's a business, I think it's the smart way to go about it. Again, data, no matter how we look at it, more from the individual data of every one of us, more concerned with our individual rights or more concerned with business, we can't run away from the fact that it is a commodity. And if it's a commodity, you should protect it. It has value, you should protect it. So I would say localization should be as an example that should be followed by everyone. I think in China there is that requirement. In Europe we speak about adequacy. I think I don't want to be controversial, but it's a clever way to speak about localization as well, because you need to adequate to the GDPR. And so, in the end of the day, it's also, you turn on the news, all the issues and controversies that have been happening is about where does the data goes, where does that get to stay. And if you see these old big investments, some announced and more public, some not announced, are all about data centers and building data centers. So where is that data stored? So I think, yes, absolutely, localization, I would say, is a necessity. And I think the countries that are not talking about it, and if we look about Europe, Europe is a combination of many states. So yes, I think there's a geopolitical side to it. Yeah. It's unavoidable. But yes, I would say localization is key, and even for a business.
Yes, and how strict, we're talking about adequacy, but how strict is this, how strict are the requirements? Can we have an idea of what kind of requirements need to be fulfilled so that a country such as Brazil, in this case, can have a positive decision in this context? What are the kinds of requirements that the European Union, I understand this unilateral decision, what kind of requirements that the European Union expect or look for when making this decision? Igor?
Giving an overview about what is required, we were discussing right now about the implementation process and how difficult it could be, and is based on the foundations of all those requirements. But I'll also bring to the discussion the struggle of monitoring and assuring the enforcing compliance of everything. This is also something that is very challenging and is considered when we are analyzing the whole structure and how the framework in some market or jurisdiction was tailored. So we do have all these core principles that we had mentioned. So all the transparency with the owner of the personal data, all the questions about the sensibility, regardless it is in principle anchored in human rights or just for commercial purpose. But we do have a straight necessity to protect and to have the transparency enough for its owner on how and where and with whom it's going to be shared and treated and processed. So all these aspects, and we have these core principles. They are analyzed by the beginning of it, how we collect through, how you are going to enforce the compliance with it. So it's a very complex equation with many variables, but the thing is, in a world fully connected like we live today, and it's unfeasible to be isolated. So this might be, regardless of what is your main purpose, to develop, and of course, considering all the different perspectives and realities, how you can provide a minimum compliance with the global requirements regarding it.
Thank you. And if I can stay just a little bit more there, because you mentioned before that you work a lot in foreign direct investment. I would like to understand if there is any connection between what we are talking about here and the reality of the foreign direct investment area. If you can share some insights there, or maybe there is nothing in common.
There's absolutely everything in common. We're talking about definition of strategy, where you're going to put your money, where you're going to make partnerships and develop your business. So the environment, not only the economic environment, but also the legal environment is essential when you are going to make this calculation. We talked about costs here and confidentiality, and how the target country or the target market can provide you all these aspects that are important when you are making all these assessments. And in terms of costs, we will define if we're going to spend more or spend less on legal interpretation and compliance adjustments of your operation. So this is a key factor when we are talking about foreign direct investments. It's part of the assessment of your strategy, where you're going to operate and to explore worldwide your activities.
Thank you. Maybe by now I still have some other curiosities, but I would like also to hear from the audience if they have any questions or comments to share with our panelists.
So it has to be interactive, huh? So we need to give us a break time now, so you can talk and then we come back again.
Yes.
I do have a question, maybe for Igor,
Yeah.
if I'm allowed,
Yes.
and picking up on something you mentioned.
Yeah.
So the whole U.S. Versus U.S. data privacy laws versus GDPR, and how Brazil positioned itself more aligned with the GDPR, and connected to localization. Would you say such choice from a political perspective or from a legislation perspective has been because aligning more with the GDPR means more individual data protection in Brazil, or would you say it doesn't have an impact? Igor.
I do believe that it does have an impact, okay, on this choice, but this is mainly about the Brazilian strategy of how it's going to position itself in the map, considering this regard. And not only this, but also Europe was in the vanguard of it. So it has a more mature legislation. It was easier to be inspired by it, because you can learn with the lessons that they already had run it through. So I believe that this is an important aspect, because it was a more mature and a more structured, and as this is more, I would say, wide or broader, it could comprehend other legislations. So this is also some kind of precaution. So we could assure that regardless would be talking to, everything would be in compliance, because were based in our legislation in a more comprehensive framework of legislation.
Thank you, Igor.
Well, let's see if we have any questions from the audience. We have here from Danilo.
Thank you to our panelists too. Not my area, but also a question for Igor. I'm interested in the Brazilian context because the concept of data being enshrined in your constitution, I'm assuming that's an anomaly, not a norm around the world. And then I'm wondering about, so after post and pre, after that condition, and you have so many states in the federation, the implementation of that for monitoring, for implementation for what's the word? For disputes, basically. Was there a planned approach, multi-year? How's it going now? How's it? Forming. I'm not very eloquent tonight, but yeah.
It definitely was a strategy to put it in a court place and in a level of legislation and protection that could affect the pace of the implementation of it. Okay, so of course, it's not, as Professor Jacquet also mentioned, we're talking about a journey, and we have to face the reality, considering that it's not going to be fully implemented or fully protected in 1 or 2 days. And this is a medium-term perspective. But when we start it from constitutional rights to be protected, we have more flexibility and even more authority to affect the comprehension of it and how we're going to structure it and how we're going to apply the fines, and it gives more authority, I would say, to structure and to implement this whole aspect and idea.
Thank you. Professor Zakite, you mentioned before that Portuguese-speaking country, except Portugal and Brazil, already have the data protection law. But in the regional context, Timor-Leste is one of the Portuguese-speaking country member. We still not have the protection law. But now, you know that last year Timor-Leste already member of ASEAN. In ASEAN, 2016 already adopt ASEAN Framework Data Protection Law. At the time, many countries already adopted data protection law. And the same way, Timor-Leste will adopt the data protection law because this is one of the requirements will be a member of the ASEAN.
Yeah.
Thank you.
Yeah. I guess it's an information, right? Yes, yeah. So thank you very much. It's true. Timor does not have data protection law because one of the issue I had when I was doing my research on cross-border data transfer between Chad and Portuguese-speaking country, I couldn't find anything. But again, I think the same as Brazil, Timor is a more constitutional right. It's enshrined in the constitutions. Data protection is enshrined in the constitution. So now, by joining the framework, ASEAN framework, which is by nature, it's also a soft law. It's not a binding law, but it set a guideline for country to adopt a data protection law. So thank you for that. Yeah.
Okay, while we wait for another question, if there will be, it just came to my mind something that I often see in terms of terminology. Sometimes we hear about harmonization. We are talking a lot about harmonization today, but it's very common also to hear another term, which is interoperability. They often are used sometimes interchangeably. I would like to hear if, based on what you think, they mean the same thing, or they are different. In what ways they are different, or how we should understand these two terms together.
Okay. I did not look into the dictionary before coming to see if same, but using my common sense, data harmonizations, it's of course is a process where you have a goal at the end is to have more alignments, which is different from unifications. Unification is to have a single document, the same content, but harmonization tolerates some differences, minor differences. Doesn't need to be same, but they are aligned together. The norms are aligned. But interoperability is a term used in data protection to explain that because of the divergence of differences or discrepancies between different norms about data protections, how can we make those laws work together? For example, how can we make an investor that is an operator that is in China want to, or let's say, let's take the case of GBA, from the GBA area want to come in Macau. So how can we make sure that these two can work together? The investor can do his business here, following the two laws, China data protection law and Macau data protection law. So one of the ways to do that is to create a mechanism that allow convergence between these two. That's why you have the standard clause, contract clause. The standard contract clause are an example of a tool to allow interoperability, meaning that allow mutual recognitions of different norms, right? So different data protection have a different requirement, but the standard clause try to bridge that together, bridge that gap together, right? So it's not only at that level, but everything we mentioned here at this stage, it's both harmonization initiative, but also some interoperability norms that put in place, like he was just mentioning now the ASEAN framework. This is a framework to allow interoperability between different countries that may have a different data protection law. So then they can use it as a reference to build up their data protection law. Right? So this is, if I may say, it's not, I mean, interoperability can be said, if I need to conclude on the topic, on my side, I'm not concluding for the others, of course, on my side, is the interoperability is a tool for reaching an harmonizations. Yeah.
And but I would like to understand a bit more about these model contracts, because they seem to be a very promising avenue to, at least in the business sector, right? I asked this question before, but I will go beyond what I asked before. But I would like to understand, how does it work? So a corporation, for example, will draft model contract, and do they need any approval, any stamp from the, for example, the regulatory authorities? How does it work so that it can work in both jurisdictions, as you are saying? Do you have any insights to share with?
So if we pick up on the, again agreeing with what Professor Diakité said, I am also the view that you know, interoperability is a pragmatic approach to the harmonization process. You still need the laws, but then you need to make sure you are able to navigate them. So when we look at the binding contracts that Professor Diakité mentioned for Europe, and the standard contract that we're looking at, the GBA, or the standard clauses for Brazil, what that guarantees is that, in my view, and maybe I'm being too practical, but is that, for instance, Macau doesn't require you to have them, but if you have a contract which is approved by the authorities, then you know that contract, there shouldn't be any issue with it. Mm. There shouldn't be any compliance issue with it, but there shouldn't also be any delay in such approval, because at the pace that things move nowadays, you need the data yesterday. Mm. You don't need it in 6 months. So by having a contract in place, it's almost like an insurance policy if the authority doesn't require you to file it because it has been approved by such authority. So, being truthful to that, line that you don't touch a team that wins, that's how I see the contracts working. How does it work? It needs, for them to be standard, I would say they're either approved by the authorities, which in this case the GBA is, or sometimes happens in other industries by associations and professional associations. But if you don't have the seal of the authorities, then you have again the problem.
Yeah.
Is the authority going to interpret it or consider it? So yes, those are the issues you need to navigate.
And can we think a bit deeper at the organizational level, at the corporate level? I wonder how companies, well, I know that we are all lawyers here, but probably we have some experience with working with clients in that area, how they organize themselves or how they should organize themselves to make sure that they comply with these different regimes that may exist, or to make sure that they fulfill the requirements that they need to operate in this global market. I don't know if Igor wants to share something.
Well, unfortunately, they will need a lawyer, actually. So the evaluation of how the business will be structured in terms of business itself, it must be considered with the background of the legislation that you are dealing with. And this is actually directly related to the question of the harmonization or the interoperability. Even when laws are not identical, how can you allow data to flow safely because protections are considered enough? Okay, so in terms of the contract clause, for instance, as we are talking about business, and business it starts or is based on contracts, and it will reflect all the terms that must be observed. In Brazil, we have this mandatory contractual clause that must be incorporated to specific safeguards, and these are clause defined by the data protection authorities. They are designed to ensure that the level of protection required by the Brazilian law is preserved once all the data leaves the country. And someone was mentioning that the possibility of having specific terms for it, it is possible, but if the parties in the contract want to adopt alternative terms tailored, for example, for a specific business model or transaction structure, it must be submitted in advance to the authority for its approval. So this is a mechanism that guarantee that you have some flexibility when you are structuring your business transaction, but it's a legal aspect of the business that must be encompassed.
Yeah, I think if I might just add, in terms of the business organization, is always how do you mitigate risk? And when we're talking about risk, I try to compile some data. For instance, in China, the penalties for breach of data privacy can go up to 5% of the income of a company. So in 2002, DD Chuxing, which I think we're all familiar, was fined by around 8 billion RMB. So the penalties are steep. So when organizing and when operating in the markets, it's also a matter of how to mitigate risk and how do you. So sometimes you might be, do I do just one contract and I put everything there, or do I do specific contracts for specific transfers? How much does that cost in terms of legal advice, legal services versus the risk that if something goes wrong, you can get a penalty from the authorities. So yeah, it's a tricky balance.
I just want to add, because I think part of your question was also how the company within themselves try to mitigate, right? So most data protection laws or legislation requires companies, depending sometimes on the size or the matters that are dealing with, to have data protection officer. So you have a data protection officer that is must be appointed by the company to deal with those. And precisely, there are some of the occasions where company need to do impact assessment, for example, right? For, as my panelist members say, to mitigate the risk, there is a procedure for an impact assessment that is required in China data protection law, and I think in Macau also data protection law require on the, of course, the supervision of the colleagues from the office. So I believe they also have impact assessment requirements where the company need to do that evaluation to make sure there's no risk that for data to be misused or badly processed. So one tool is to have those data protection officers to guarantee that the company can fulfill its commitment and obligations under the law.
Okay, we are almost at the end of this session, but how does the future look like regarding data protection? I think about the different models that we have. Some are more pro fundamental rights, some are more pro business, if we want to say. We have heard some, for example, from the United States complaining on how much, for example, the European Union is fining their companies, how much fines they are receiving in Europe, and that this is not good for business, not good for innovation, etc. I wonder which direction the future will take us. Well, I'm not. I know that you're not magicians, but
yes, I forget my crystal ball at home.
But I would like to hear your view on this point. I don't know if Igor, you want to start, and then we maybe with closing remarks as well, because we are about to finish.
Sure. Well, I believe that it's clear that we are increasingly speaking the same regulatory language, despite all the difference, but we can identify shared principles, shared safeguards, increasingly compatible tools. So I believe that this can show us the real value, but not only the real perspective of having some kind of harmonization. So this is a matter of increasing the trust in workable methods for innovation, cooperation, global interaction. So this is my understanding for what is about to come.
Well, anything else from the other panels before I close the curtains?
How the future look like? Well, I think based on everything we mentioned here, to me there is, of course, a progress, but the progress is slow toward having a system of data protections that is unanimously agreed by all parties in this regard, simply because now, as I mentioned earlier, we have a lot of fragmentations. Fragmentations mean that different law require different things. But with what we have seen since the GDPR, we have seen a lot of alignments with what the model of GDPR. Should that model become the features of data protections as it is now, or will require some adjustment to adjust, to adapt to the different stakeholders? That is something to be explored in the features. Probably next time again when we come here, we are going to see what's happened till then.
Well, with this, unless you guys have anything else to add, otherwise I will conclude with this session. I would like to thank the speakers for their time and dedication to this session. I would like also to thank, in the name, of course, of the Faculty of Business and Law, and if allow me, the Rui Cunha Foundation. I would like to thank everybody that came here today and those that are online with us. I would just like to mention that this is part of a series of talks. We will have a potential. We will have. I think the next session will be in March, but we will share the information the same way that we share the information regarding this talk, and hopefully we will continue with these talks in the coming academic year. This year we're focusing on data protection. We'll see which area we will choose for the next year, but just stay tuned because we will bring more interesting conversations here at the Rui Cunha Foundation. Thank you very much for providing us with this amazing space. Thank you very much.
Yes. And now that I have been relieved from my role as a panelist, now I can address you to just give us 1 minute. We need to give the certificates to the panelists, and of course your round of applause will be required, right? So just a moment. Okay. It's me. Okay. No. Okay. Yeah, the table. Yeah. No, let's go to the table. Inside, no?
Na página do YouTube, porque isto está a ser online no Facebook, mas depois eles postam no YouTube. Tá?
Ok, é boa.
Sim, então.
A família vai gostar de ver.
Sim, pode ser. Onde é que está?
This is, yeah.
Ok.
Esses coreanos, mas a família do meu lado está em Portugal. A minha mãe morou muito tempo em Moçambique, até aos 17 anos. Até aos
It's the
17.
same, right? It's also blue, right?
Costuma lá ir.
Sim, vou sempre. Vou pelo menos uma vez ao ano.
Eu fui em 2000, antes do Covid, pela primeira vez, e adorei.
Eu fui
Are they signed by you already?
Huh? Yeah, I will sign, yeah.
3 vezes porque
Uau. Claro.
estava a tirar a carteira de advogado. Acabou.
Ok. E está inscrito lá?
Agora já estou inscrito.
Boa, fantástico. Há muita coisa a acontecer. Não é? Isto agora deu
Okay. Do you mind giving the certificate to the speaker? Okay.
No, you are organizer.
No, I will be with.
Right next to me.
Okay.